Start. This decision was considered by Supreme Court again in Sambhunath Goyal versus Bank of Baroda, Jalandhar, 1978 within bracket 36 bracket close FLR 195, in which it was held that a reference under Section 10 of the Industrial Disputes Act was an administrative act of the government, on the basis of an opinion formed by the government as to the factual existence of an industrial dispute. Full stop. In Ram Avatar Sarma within bracket Supra bracket close, the Supreme Court again reiterated that the government only performs an administrative act while making or refusing to make a reference under section 10 of the Industrial Disputes Act, and that it cannot delve into the merits of the dispute or take upon itself the determination of the list between the parties. Full stop. The Supreme Court held that the appropriate government could only refer when a dispute existed or was apprehended, and for that purpose, the state government was permitted to determine, prima facie, whether an industrial dispute existed or that the claim was frivolous or bogus. Full stop. Similar view was again reiterated by the Supreme Court in Sarad Kumar's case within bracket supra bracket close. Full stop. In the light of the aforesaid decisions, it is necessary to examine the reason given by the authority to ascertain as to whether the reasons given was germane to the issue or not. Full stop. From a perusal of the impugned order, it is clear that the state government has declined to raise the dispute on the ground that the petitioner was not a workman under the Industrial Disputes Act. Full stop. In my opinion, the reasons given by the authority tantamount to an adjudication, which is impermissible. Full stop. Adjudication is the function of the tribunal or the labor court, and the state government or its delegated authority cannot remit to itself that function, which is exclusively vested with the industrial tribunal or the labor court. Full stop. Consequently, the state government was not competent to hold that the petitioner was not a workman within the meaning as defined under the UP Industrial Disputes Act. Full stop. Such a matter could only be adjudicated or decided by the tribunal or the labor court on the basis of the material placed before it by the parties. Full stop. In a similar matter, in Telco, Convoy, Drivers, Mazdoor Sangh and another versus State of Bihar and others, 1989 within bracket 3 SCC 271, the Supreme Court held that the dispute, as to whether the persons raising the dispute, are the workmen or not, the same could not be decided by the government in exercise of its administrative function under section 10 within bracket 1 of the Industrial Disputes Act. Full stop. The said judgment is squarely applicable to the present facts and circumstances of the case. Full stop. The court is of the opinion that the state government exceeded its jurisdiction and has attempted to usurp the power of the tribunal by adjudicating a dispute which power was not vested with the government. Full stop. In view of the aforesaid, the impugned order, passed by the Deputy Labour Commissioner, declining to refer, the dispute cannot be sustained and is quashed. Full stop. The writ petition is allowed. Full stop.